Whenever I'm dressed like this, it's either because I'm going to court or going to a party. Spoiler alert, I'm not going to a party. Mwah. It was a year and a half ago that I started this video of what was supposed to be a day in the life of an attorney, my last trial ever. For those of you who haven't seen that video, the punchline was that I got sick with the stomach flu for the trial. We're gonna have to carry this on elsewhere. I got sick for the trial and missed my first and only day of work ever in my life. We had to reschedule the trial. It's a year and a half later. The trial has come up for trial. Alright, and I'm leaving early to get there early, and when I say that I'm leaving early, it's not to get there early. I'm leaving early to get there earlier than the early that I want to get there to make sure that I'm early. When it comes to court and when it comes to anything in life, you are better off being 1 hour early than 1 minute late. Especially true when it comes to trains. Think about it. I spent the weekend preparing for this trial, and I spent one of the days of the weekend prepping the witnesses. This whole process is reminding me what it is I love about the practice, what it is I absolutely hate about the practice, what made me good at the practice, and what about the practice drove me crazy. So we'll talk about that in a bit, but on the way to court, we're going to talk about prepping witnesses and prepping for examinations, because it's an amazing thing, it's super interesting, and it's also super soul-crushing in a way, but we'll get there. For anyone expecting the camera to fall, joke's on you, I got a tripod for this thing now and it's sticking to the dashboard like a champ. Alright, so prepping witnesses. Prepping witnesses is a delicate and tricky situation because it involves treating your client or your witness the way opposing counsel is likely going to treat them, which is not good, which is not pleasant, and which is overall aggressive and adversarial. A mistake that a lot of lawyers make is when they prep their witnesses, they get them to rehearse their story, tell it, you know, as though a friend is asking them what happened when they're at a house party or something. That doesn't prepare a witness for cross-examination. On the contrary, that actually brings them into a cross-examination less prepared than before. Oh no, oh, whoa, nice one. I guess actually we should go back now and just describe the process of what happens when you call a witness when a witness testifies before a judge. In law, you have your witnesses, your party, the witnesses that you intend on calling, and the other party has their witnesses that they intend on calling, and these witnesses can overlap. For example, you would call the opposing party as a witness 99% of the time, even if the opposing party does not intend on examining their own client. And it goes the other way around. Opposing counsel is going to call your client to testify, even if you don't necessarily have the intention of calling your own client to testify as a witness. But the treatment of these witnesses, depending on what kind of witness they are, varies depending on the kind of witness that they are. One of your own witnesses, your own client, a representative of your client, you can't ask them what we call leading questions. You can only ask them open-ended, broad questions like, tell me what happened that night, where were you on, how did it occur? You can't ask them leading questions to the effect that on February 15th you were at X, Y, and Z address. That's a leading question. You have to phrase it in an open manner. Where were you on whatever date it was that I just said 2 seconds ago, which I now forgot. The opposing party and what we call hostile witnesses, you can ask them leading questions. Is it not true that? Those are leading questions because the question presupposes a bit of the answer. So your own witnesses, you have to ask open-ended questions to. You have to let them elect the information and tell their story without looking like they're being directed by you as their attorney. Some judges will refuse questions that are leading questions. Sometimes judges are going to allow the question, even if it's a leading question, and they're simply going to tell you, Maître, lawyer in Quebec, you're asking leading questions. Go ahead and do it for as long as you want, but just know it's affecting the credibility of your witness. Because if your witness is not able to elect the information and the evidence and the story to support their case without being prompted by their lawyer with leading questions, it affects their credibility. Camera's going down. Alright, and the good thing about being an hour early is that you get to prepare mentally and paper-wise, which is what I'm going to do now. Oftentimes, if you're asking leading questions to your witnesses, opposing counsel will adopt a strategy which I frequently use, which is just, I'm not going to object anymore, Your Honor, but just know that this greatly affects the credibility of the witness, who seems to be unable to tell their own story without being prompted by their own attorney. But now bringing this back to prepping your witness for both examination in chief and cross-examination. Prepping your client for their examination is relatively easy, it's relatively relatively straightforward. You need to go through their story. They need to remember the details that they're going to tell a judge, because if they forget a detail, it becomes a tricky situation for the lawyer to try to prompt them to recall that detail without asking them leading questions. If you know for a fact that your client just forgot to say something critical in their testimony, it becomes a strategy that a good lawyer can employ, which is to ask them a question which will trigger that memory to prompt them to go back and clarify or add the detail to that question. So prepping your client is easy, straightforward. You don't present to them any document that they haven't seen before. Every document that you do present to them during their testimony, they are familiar with. I've got to tell you, as a lawyer, nothing is funnier in a sad and uncomfortable kind of way than when a lawyer asks his or her client a question and the witness doesn't know the answer to the question. Or the lawyer shows a document to the witness and the witness is like, I've never seen this document before. There are a few things that make a lawyer more uncomfortable than surprising their own witness in their own examination in chief. Prepping your client, that's easy. Prepping your client for a cross-examination is much more delicate and much more, how do we say, uncomfortable. And some lawyers are too shy to do it the way it needs to be done, and that is a mistake. When you are prepping your own client for cross-examination, you are no longer treating them like your client, with respect, with deference, with credulity. You no longer believe everything they say. You're no longer listening to them to let them tell their story. You have to prep them for a cross-examination the way any reasonable, competent, intelligent attorney is going to cross-examine that witness, which is going to be vigorous. It's going to challenge their credibility. It's going to challenge the accuracy of their details. It's going to challenge their memory. It's going to challenge who they are as a person. And when you're doing this to your own client, oftentimes your client is going to get mad at you and they're going to say, look, you're supposed to believe me. Why are you treating me like this? And I say, if you can't deal with it coming from me, you're not going to be able to deal with it coming from opposing counsel. You have to do the job of opposing counsel when prepping your witness, whether or not your client is going to be angry or resentful at you for having done it. I was particularly good at this because I really didn't care if my clients got angry with me. And there is some sort of sick pleasure that a lawyer gets by getting their client to get angry with them while prepping them for a cross-examination, because you know it means that you're doing a good job. When you prep your witness, you have to test their story, you have to challenge them, you have to break them down, as will opposing counsel. Opposing counsel may or may not be good at cross-examining. They may or may not be intelligent, well-prepared, whatever, but you cannot prepare on the basis of your adversary's lack of preparation, incompetence, or lack of intelligence. My father always told me, and it's something that I'll never forget, you always, without exception, without compromise, have to assume that opposing counsel is smarter and better prepared than you, which means that you're going to have to work harder and be more diligent to ensure that you're one step ahead of someone who you have to regard as being smarter and more intelligent than you, even if they're not, even if you know that they're not, even if you are 1000% certain that they are not, they might have a good day. You know, you could be 400 points better than someone in chess and they can still beat you 1 out of 10 times. And cross-examining the opposing party. Getting back to what I love and hate about the practice, what I'm great at and what I hate being good at. I'm good at making the opposing party cry in cross-examination. And not through abuse and not through condescension and not through demeaning name-calling. At breaking them apart and picking apart their story to the point where they acknowledge and recognize in front of a judge that it no longer makes any sense and that it's no longer tenable. Now, it doesn't always happen because sometimes the story does make sense and it's a question of law that a judge is going to have to decide on. But I have a knack for breaking people down who are lying. I don't like doing it because at the end of the day, there is a person behind that character that I have to deal with in this play called litigation. There's a person behind it with emotions, with a soul, with a being that is going to have a very bad day, even if they deserve it. But it still doesn't make you feel good as a person to ruin someone's week. The one thing that always drove me crazy in the practice of law is you have to sit through the opposing party's examination of their own client. You have to sit through the whole story, and as much as you want to jump up screaming, interrupt, say that's a lie, this is a lie, you can't. You have to wait for that chapter of the story to be over before you can start writing your own. And it is exquisitely frustrating because as the youngest of 5 kids, it's not the way I was brought up. When we had arguments at the dinner table, everyone would cut off the other person and interject when they said something silly. It was a heated battle where everyone would interrupt everybody to address specific points as they arose. But in law, you can't interrupt. In law, you have to be polite, you have to wait, you have to give them their turn, then you get your turn and they can't interrupt you. So you have to remember every point that you have to go over, but you can't remember it, nobody can, so you have to write them down. You have to be meticulous about coming back to the inaccuracies that arose during the testimony. I'm going to go in there and get prepared and come back out after I have hopefully successfully, cynically, hopefully successfully destroyed the opposing party in this case, which I think should not be very difficult to do given the documentary and photographic evidence that we have in the file. So back in 4 or 5 hours. I'm not kidding you, we didn't get heard today. We have been rescheduled. We will be guaranteed to have an entire day and a dedicated judge in advance, so there's no chance we show up and there's 5 other people in front of us who have to go through their trial before we can get to ours. Oh, that's what's really irritating. This, by the way, was not the intended lesson of this video, but the most difficult thing in the practice of law is getting back into a file when it comes time for trial, because regardless of how well you knew the file a year and a half ago when you were deep into it, getting everything ready for trial, with the mere passage of time, you lose the reflexive knowledge of the file, and you have to go and get that back in your brain every single time that file comes up, either for trial, for a hearing, for a court date, for whatever. It's the most difficult thing because it's not a learning curve per se, it is rather a rememorizing curve that occurs every time you have to pick up the file to do something in it. And it's not something you can bill your client for if you are a lawyer with a conscience, because there's no reason why your client should have to pay to refresh your memory. So, the more these types of postponements or continuances happen, the more, call it billable time, but just call it the more of your time gets eaten up because you have to put the file on a shelf, wait for that next date to come around. The next date comes around, you have to go redo everything, go through the documents, go through the pictures, go through the evidence, go through the jurisprudence, go through your notes, go through your questions, because you just forget. Now, luckily, we're scheduled to, in the near future, so all of the prep that I've just done over the weekend and over the last few days will not have gone to waste, and that's it. Let's roll. Go home, pick up the kids from school. Booyah! That's yet another day in the practice of law. Hurry up and wait. That's what the game is called. If you like this video, like, share, subscribe, hit the notification bell. We do a lot of stuff on this channel: cooking videos, fishing videos, GoPro drones, law vlogs. I'm gonna keep doing these law vlogs because as long as I have anything useful to contribute to the community of law, I will do so through video, because that's how I talk to the world now. Another postponement. It's the trial. Ooh, the camera's going down. Camera's going down.